Don?
Yeah, Jamin says the Fairness Doctrine is well-intentioned, and I really don't know how he knows that. I don't think you would say that the doctrine it replaced, which being here at the Mayflower, I'll call the Mayflower Doctrine, because that's what it was called, in the 1930s, which said that the stations couldn't editorialize, was not well-intentioned. That was a New Deal policy to stop anti-New Deal radio stations from editorializing. In fact, the newspaper broadcast the cross-ownership ban was also a New Deal policy to try to limit anti-Roosevelt newspapers, okay? Yes, it's been bipartisan. The Eisenhower administration didn't give out a lot of TV licenses to anti-Eisenhower newspapers, but they gave out a lot of licenses to pro-Eisenhower newspapers. That study's been done too. So there's a lot of non-well-intentioned monkey business under the public interest standard, and I'll refer you to what's happening now in cable news. With all the controversy, it's completely lost that if you believe in free speech, what we have in cable news is exactly what free speech looks like. And it's so much more free than what we had when we had 15 minutes of 3 lookalikes on the evening news in 1962, whose executives were all having dinner at the White House, by the way. And talk about their talk about the network affiliations of the president's radio and television stations. But the fact is that the cable industry was barred by law, okay, effectively for about 15 years. According to public interest proceedings that take exactly the well-intentioned values that we're talking about here and said that it was against the public interest for cable television operators to siphon, I love to use the word because that's actually the word they use, to siphon viewers from broadcasting on the grounds that cable would never be a primary service, could only be ancillary, could only be a little fill-in to broadcasting. And to protect broadcasters from competition, they had a host of anti-cable television rules that suppressed things like C-SPAN and CNN and MSNBC. That's supposed to be an applause line here. And Fox News. And Discovery, and A&E, and all the rest of it. And all the choice, all the broadcast choice we have that's not to us from terrestrial broadcast, but from satellite broadcast and spectrum in a tube, the cable industry, and through broadband now, all that video choice was against the public interest because it siphoned viewers. And it is a new day, okay? We don't suppress YouTube because it's siphoning viewers from Discovery. But that was the policy. And that's what you get with licensing rules that give these administrative agencies discretion to decide what constitutes fairness. And so when it's done in any other context, you have to be very careful with that. And these rules about localism, when we could go into a whole discussion of how localism is actually hurting minority-owned radio and television stations, and they're up in arms about the localism rules. And we could certainly go into the way these Media Matters and their policies that they endorse for limiting the number of network affiliates of the broadcast networks, actually create the actual places that companies like Sinclair Broadcasting occupy, which they hate. They hate Sinclair Broadcasting, but Sinclair Broadcasting is out there because ABC can't own those affiliates. And so other companies come in to be group owners that operate in that regulatory creation. And then they worry about the problem with Sinclair Broadcasting. So they're actually completely incoherent rules at the end of the day that don't even accomplish the sorts of censorship that's attempted. So I'll stop there.
Next.
Thank you, Chief Judge. This question is actually for all three. As much as I'd love to spark a discussion on whether Mark Lewin is an Appointments Clause violation, instead I have a question on the constitutionality of the Fairness Doctrine. All three panelists have referenced Red Lion Broadcasting versus FCC. With the exception of one oblique reference from Professor Raskin, I didn't hear anyone discuss Miami Herald Publishing in 1974. And I would be curious as to how you would distinguish, all three of you, Miami Herald from Red Lion. Is it that you think Red Lion is predicated on free speech and Miami Herald was the free press clause? Or what would you say to the proposition that Miami Herald may have overruled Red Lion sub silentio, or at the least abrogated it?
Actually, I think I did address the Miami Herald versus Tornillo decision. This was the letter to the editor reply statute that was passed in Florida. I mean, I think that the court distinguished it on the proper grounds, which is that, at least theoretically, there's an infinite amount of newspaper ink and newspaper, and those are all private entities. It's very different setting and context than you get with the regulation of the broadcast spectrum and what its origins were. That was how the court distinguished it. And remember, the court felt that not only did the Fairness Doctrine not violate the First Amendment, they felt that the Fairness Doctrine enhanced the values of the First Amendment by guaranteeing the right of reply, meaningful political dialogue, and so on. Now, everything that Tom says about the chilling effects are true in the sense that, you know, if I know that my newspaper or magazine, or in this case radio station, is going to have somebody, you know, give time to somebody to come in to reply, then I might say, okay, let's not run the ad, you know, or let's not run the, you know, the editorial, you know, decrying the guy's work as communist infiltrated or whatever, if I know that I'm going to have to turn over time to him. So that's one of the reasons that it didn't work out so well in practice. But as a constitutional matter, I think the court was right, and the court has never overruled Red Lion, and the court has never backtracked from that decision.
I'll make one quick point, and that is, if Marconi had invented his invention prior to 1787, it would be covered just like the press is in the First Amendment. It's only a matter of technological timing.
Yeah, and we hope we're heading that way. Yeah, there are a lot of things I didn't mention in my 6 minutes. But
you took more than 6. But who's counting?
And Miami Herald, I'm delighted to answer the question. If there be any doubt what a perversion of the law Red Lion is, can you imagine First Amendment jurisprudence? And I can take free shots at this, Judge, because I'm an economist. I can't be sanctioned. Not a lawyer. But look at this. Red Lion, the Red Lion radio station, is a radio station that I'll bet nobody in this room has ever listened to or probably even heard of outside of the context of Red Lion versus FCC. It sold time for $7.50 per 15 minutes. Okay, it was run by an unorthodox guy, a right-wing minister, just one guy. And it got to the Supreme Court bundled with another case, the RTNDA case, which was the suits and the news directors. And Archibald Cox, who was on that case as an attorney for the losing side, he said, you know, we should have dropped one of the parties here. And you think, well, you're going to drop this right-wing minister. No. That's the guy you needed in that case. You should have dropped the suits and the networks. You should have just gone with one unorthodox guy with a small station, okay? And it would have made a huge difference, said Professor Cox. Anyway, compare what happens in Red Lion, a radio station with no influence, no power, you know, can barely stay alive, and the Miami Herald. The Miami Herald, the most powerful press institution in the state of Florida, attacks a guy running for the state Senate, Pat Tornillo. And Pat Tornillo says, I have a right to respond under 1913 Florida statute. You got to give me, you know, they said, well, you publish a letter to the editor. They said, no, I want equal space in your paper. They say, get lost, we're a newspaper. We have editorial discretion. They lost in the Florida courts. Florida Supreme Court upheld the Florida statute. They went to the Supreme Court. Supreme Court goes 9-0 the other way, overturns. And they say, we're not even going to look at natural monopoly arguments and all this stuff about power and influence and how, you know, how valuable their newspaper franchise is. Baloney. This is the First Amendment to the United States Constitution. They have editorial discretion to give this Pat Tornillo, a candidate for public office, a right of reply or not. That's the First Amendment to me. That's the First Amendment to 9 Supreme Court justices that got it right. They were confused by the radio spectrum frequency thing, like it's different because it's invisible, and apparently we're still confused by it. There should be no confusion, at least after I've, you know, amortized my investments in understanding it.
Okay.